Welcome back and thank you for staying with us. Now to judicial matters. An appeal court sitting in Port Harcourt has directed all parties involved in the appeal filed by members of the Rivers State House of Assembly loyal to FCT Minister Nyesom Wike to maintain status quo pending the hearing of the substantive suit. The 27 pro-Wike lawmakers, led by Martin Zamawule, had defected from the People's Democratic Party to the All Progressives Congress, APC. They had gone to the court to stop moves to declare their seats vacant. The three-man panel of the appeal court, which sat virtually on Friday, adjourned the hearing of the substantive matter to June 20th, 2024. To discuss this, I'm joined by legal practitioner Tunji Abdul Hamid. Hello, Tunji. Thank you for joining us at this time.
Thank you for having me. It's my pleasure to be with you.
All right. So now the Federal High Court sitting, in Abuja, ordered all the parties to maintain status quo in Rivers State. What do you make of the ruling in light of how heated up the state has been on the last few months?
I think that is the best in the circumstance because what it means is that parties are required to stay the way they had before the matter was in court. In other words, if you recall, the matter went to court by the new speaker, who says who was asking the court to restrain the 27 lawmakers and Amuli-led House of Assembly from parading themselves as members of the House of Assembly and from parading themselves as speaker. So based on that, there was an ex parte order that they should not parade themselves as members of the House of Assembly again. They went to court and they went on appeal in that regard and asking the court to stay execution of that judgment pending the termination of the appeal. That was what the court looked into. The court looked at the motion for stay of execution and believed that, look, if he should grant that stay of execution, indirectly is granting the order in the main appeal. Therefore, he has entered into the substantive suit. And in our law, you cannot determine substantive suit at the interlocutory stage. So the court has done the right thing by asking them to maintain status quo, pending when the main appeal will be determined. So which means, as it is today, Amewuli and the 27 others are not recognized as members of the House of Assembly, and that their seat is currently declared vacant until it's set aside. So the appeal will be determined to determine whether or not they will still remain or not. Right. While that is going on, we cannot stay execution now until that is done.
All right, now, Martin Zamawule, on behalf of 26 others, had challenged the decision of the Rivers State High Court, which vacated their seats and also restrained them from sitting or carrying out any legislative function. Now, what is your legal disposition, or what is your disposition to legal moves like this when the Constitution is clear on matters of political party defection?
You see, though the matter is in court, I will try as much as possible to look at the merit of the case. But there is no way we'll talk about it and not talk and make reference to the law. We are in a country where people don't obey the law, and that's why we are where we are today in this issue. The law is clear. Once you declare for a party other than the party that brought you into power, you are to a particular member of the House of Assembly or National Assembly member, your seat must be vacated. You don't have to be told. But we are in a country where people want to drag the issue and then bring an unnecessary argument because they were of the opinion that, look, they fall within their case falls within the exception in that case. What is the exception? Exception is that if there's a division in the other party, they are claiming that because there's a dispute as to who is the right secretary of the national secretary of the PDP, there's a division, and later they can defect. They've defected, and this was done even openly. And I'm even surprised that a court in Abuja will say that though it was a obiter dicta, not part of the judgment per se, that their seat has not been declared vacant because of the fact that there was no any membership registration to show that. That does not matter. That case is different from the one the court is looking at. This one, there's a publication, there's a video, there are audios, there are videos, there are everything on ground to show that they actually defected from PDP to APC. So relying on the previous precedent, which talks about for you to determine whether somebody has defected or not, the register of the party must show this and that. That is the facts are not the same. In those other cases, the man did not declare openly. There was no any open declaration. There was no any video. and he denied it later. So in that regard, for you to say yes, it clearly defected, you must show evidence. But in this case, there are clear evidence that
all right, still talking about, still talking about, evidence and how clear the law is. Would you say it is constitutional, or it is constitutional to claim that neither President Tinubu nor Governor Fubara has the statutory powers to stop the Independent National Electoral Commission from conducting fresh elections to replace the 27 Rivers State lawmakers that defected? And this is, based on the agreement that was initially reached.
Yeah, that agreement was not in line with law. There's no agreement as far as I'm concerned. Just a mere paper understanding between parties, and that's not the law. In fact, I have often maintained that, look, you can't resolve a constitutional matter by way of a political agreement or by way of an amicable resolution. The law is the law. You must follow the law. So whatever that has been signed between the president and Mr. Fabora or any other person, it's just a mere paper or understand. It has no basis in our law, and they cannot. None of them. Nobody can stop their seat being declared vacant except the court. The court is the only organ that can stop them from being there, that can stop them for their seats from being declared vacant. No agreement. No matter, the president cannot override the law. The president is not above the law. The agreement has no basis under our law. So you cannot determine constitutional matter by way of an amicable resolution or political solution. When people talk about the need for us to have a solution to this, we are burying the law, and we are making things difficult for ourselves. You don't do that. You don't sort out issue of constitutional matter by way of political solution. It cannot work. It can only work for temporarily. Thereafter, we will see the situation and thereafter. And that's what we're seeing today.
So what do you think would eventually play out in Rivers State, as the power tussle revolving around the governor and the FCT minister, and their loyalists continue to linger?
Now, without prejudice to the matter in court, what I see is that, look, governance will suffer in Rivers State. That's one. Two, these people, the 27 lawmakers, I don't see them coming back to that House of Assembly. If we are going truly by our law, they cannot come back to that seat as member of House of Assembly without prejudice to the case in court. And unfortunately, as it is today, Rivers State, Rivers State people are the ones suffering it because the governance will have to stand still. Because there is dispute now as to where the governor will take his request to if he wants to seek anything from the House of Assembly. Though he has recognized the new speaker, I can't remember his name now, Victor or something. He can go there. But although there are also arguments as to whether or not 3 people can now form a quorum and start sitting as member of House of Assembly. They can, as far as I'm concerned, because as far as I'm concerned, those other people, they were elected there, and the other people absented themselves from the office, and their seats have been declared vacant, which means the quorum now, as per the Rivers State Assembly now, be based on the 3 of them or 4 that is left in the House. The other section that people are relying on regarding for there to be a constitution, that for House of Assembly to be constituted, there must be not less than 1/3. That is to say, you cannot say you have a House of Assembly from the start if all the constituencies are not up to 1/3 of that. Not that there must be 1/3 from the start to the end for you to say you have a House of Assembly in place.
Right.
So as it is now, since they are left, their seats can be declared vacant, and other people can be elected to replace them. For me, the only problem I have is that governance is suffering in Rivers State. But whether they will come back or not, I think, except we are not following the law the way it should be, they should not come back and will not come back. All
right. Well, thank you so much. We appreciate you for your expert's opinion on this issue, Tunji. Thank you.
Thank you for having me. It's my pleasure to be with you. Thank you.